The Complete Bridelawyer Guide, Part 3, How Wills Actually Work Step by Step Without Overwhelm. Hi friends, welcome back. I'm Morgan Weil, co-founder of Bridelawyer, and today we're doing the final part of this 3-part series on wills. And honestly, this is the part that freaks people out the most, until they hear it explained simply. Today we're talking about how wills actually work and how you can make one, what they cover, what they don't cover, who you pick, how you sign, and what estate planning really means, minus the scary vocabulary. The whole goal of today is to demystify this. By the end of this episode, you will know exactly what the process looks like, step by step, without stress and without confusion. So let's start at the beginning. First, what's the difference between a will and a trust and an estate plan? People hear these words and think they need a law degree in order to understand them. You don't. So let's break down these nicely and simply. A basic will, this is what most people actually need. A will that says who gets what, who runs your estate, who takes care of minor children, and how everything else, the things you didn't specifically name, gets divided. A simple will is completely sufficient for the majority of families. You don't need to be wealthy. You don't need to have, complicated assets. You just need clarity. A trust. Here we are talking about a revocable living trust. These trusts are like containers while you're alive. You place assets into them, like your home, certain bank accounts, and sometimes investments. You are the trustee while you're alive, and when you pass away, the successor trustee you named steps in. These types of trusts avoid probate, is often faster, keeps things more private, and can be extremely helpful for blended families or people with complicated assets. These trusts are especially popular for people with significant wealth, people with multiple properties, parents or grandparents who want to control timing of inheritance, people who value privacy, people with delicate family dynamics. Those who want to avoid long probate timelines, a trust is not always necessary, but when it is, it's powerful. And usually when attorneys prepare trusts, they often prepare a will to go along with it. So if anything is left out of the trust, usually because someone forgets to change a deed or something, it pours over into the will. There are a lot of different trusts out there. One you heard above, the most common, the one we've been talking about, is a revocable trust, meaning you can change it at any time. Yet our laws provide for other types of trusts. Often these trusts have tax advantages, but the trade-off is once you create them, they can't be taken back or revoked. They are called irrevocable trusts. An estate plan is full package. Think of it as the whole umbrella of everything you might need. It often includes a will, one or more trusts, powers of attorney, medical directives, sometimes tax strategies, sometimes more advanced planning tools if you have substantial assets. Especially in states like New Jersey and New York, a full estate plan is important because the government can take a pretty large chunk through taxes if things aren't structured properly. So, not everyone needs the Rolls Royce of estate planning, but if you do, a lawyer will absolutely tell you, do you have legal capacity to make a will? This is the first requirement of any will. Capacity basically means you must be 18 years or older and you must be of sound mind. And let me stop you from overthinking right there. The legal standard for sound mind is much lower than people assume. You do not need a perfect memory, perfect cognitive functions, a medical evaluation, a flawless day. You just need to understand 3 simple things. 1, what you own. 2, who your close family members are. 3, what the will is doing. That's it. What about dementia? This comes up constantly. Every state is different, but many allow people with early or moderate dementia to sign a valid will if they understand these basics at that moment. I know, lucid in that moment. Here's a New Jersey example, because New Jersey is very clear on this. In New Jersey, a person has testamentary capacity if they understand their family relationships, the natural objects of their bounty, know the nature of their property, and understand that they are signing a will. This standard is lower than the capacity needed to sign contracts or medical directives. So yes, people with mild dementia or cognitive decline often still have the legal capacity to make a will. So what does invalidate capacity? Being extremely intoxicated, being heavily medicated, being on substances that impair judgment, hallucinations, delusions, being pressured or threatened, being tricked into signing anything a will must be made freely and clearly. So can you write your own will? Technically, yes. Should you? In 95% of cases, no. Most self-written wills end up invalid, partially invalid, missing crucial sections, signed incorrectly, witnessed incorrectly, or written in a way that cannot be interpreted. And here's the heartbreaking part. If your will is not executed exactly as your state requires, that law treats it as if you had no will at all. And all of your effort, all your intentions might mean nothing. So, what does New Jersey require for a valid will? Let's stick to New Jersey, since that's where so many brides and couples ask us about it. A valid will in New Jersey requires 1, the will must be in writing. 2, the testator, the person making the will, must sign it. 3, there must be 2 witnesses watching the testator sign. 4, witnesses should be disinterested, meaning they're not inheriting anything. And while it's not legally required, most wills are notarized through what's called a self-proving affidavit. Why notarize? Because witnesses move, witnesses die, witnesses forget, witnesses lose touch. Notary removes the need to track people down years later. It's a huge help. Most attorneys use staff as witnesses. Banks sometimes use tellers. Anyone disinterested can do it. So, how do you actually start a will? Let's break this down step by step, like we're sitting together at your kitchen table with iced coffees. Make a list of what you own. Include bank accounts, investment accounts, retirement accounts, your 401k from your 4 jobs ago, property, car, jewelry, sentimental items, digital assets, photos, passwords, domains, business interests, pets. You'd be shocked how many people forget half of what they own. 2, decide who gets what. Think in 2 categories. Specific gifts. These are the I give my diamond bracelet to my niece items. These usually include things with sentimental or family meaning. Jewelry, heirlooms, artwork, items from childhood, special collections, everything else, the residue. This is called the rest, residue, and the remainder. It includes anything not specifically named, forgotten items, leftovers, future assets, and you can leave your residue to 1 person, multiple people, equally, percentages, a charity or a trust. This 1 paragraph handles most of your estate. 3, choose your executor and your backups. This is a huge decision. Your executor is the person who handles your accounts, pays your bills, works with lawyers, organizes paperwork, sells your property if needed, distributes everything, communicates with family. They must be organized, honest, financially responsible, emotionally steady, and yes, absolutely need a first choice, a second choice, and a third choice because life happens. 4, if you have children, you must name a guardian who raises them, a trustee who manages their money. These can be the same person or different people. Most parents set up trusts that Release money at ages like 21, 25, or 30, because very few 18-year-olds are ready to inherit everything at once. A will protects your children financially, emotionally, and legally. 5. Should you write someone out of your will? Sometimes, yes. You don't need to write a dramatic paragraph. Just a simple line confirming that you intentionally left someone out prevents that person from saying, "She forgot. That was a mistake. She wasn't of sound mind." It protects your wishes. 6. Funeral instructions. Many people include funeral instructions in their will. But here's the issue. Most wills are not opened until days or weeks after the funeral. So if you have a specific burial preference, preferred outfit, ceremony instructions, religious or non-religious requirements, music or readings, you want to put those instructions somewhere accessible and tell your loved ones where it is. Your will can authorize payment of funeral expenses, but the money is often not immediately available. Someone may pay and then be reimbursed. And a will does not control assets that pass by beneficiary designation. This includes life insurance, 401ks, IRAs, pensions, TODs, POD accounts, many brokerage accounts. Whoever is listed as a beneficiary gets the money, even if your will says something else. So yes, after you get married, divorce, have kids, or change your mind, update your beneficiaries. How an attorney actually prepares a will. Let's go through the process. 1. The consultation. You sit down with your attorney, often for an hour or two, and talk through your family, your relationships, your assets, your goals, your concerns, your dynamics, tax implications, business interests, possible trusts. They'll tell you whether you need a simple will, a will with trusts, a revocable trust, a more advanced estate plan. 2. Drafting. The lawyer prepares. You review everything. You ask questions. You make edits. You customize. This part should feel collaborative, not intimidating. 3. Signing. The execution part. This is where the legal magic happens. In New Jersey, you sign. 2 disinterested witnesses sign. A notary signs. The affidavit you sign. The will. Supporting documents. Acknowledgements. Your attorney keeps a copy. You take the original. You may give a copy to your executor, but that's optional. 4. Store it safely. Fireproof box. Home and safe. Attorney vault. Anywhere secure and waterproof, and let someone know where it is. Why you should provide a list of assets. There is no universal database of what Morgan owns without a list. Your executor has to, be a detective, work your entire life. A simple list prevents assets from being lost, makes probate faster, ensures nothing slips through the cracks. You would be shocked how many estates lose track of retirement accounts, insurance policies, old savings bonds, digital assets, stock certificates, and safety deposit boxes. One list solves this. Changing a will. How often and why a will is not a tattoo. You can change it anytime as long as you have capacity. Most people update their wills when they have a child, they get married, they get divorced, someone dies, someone new enters their life, they gain new assets, they sell a business, they move states, they change their mind. A good rule of thumb, review your will every 3 to 5 years. Even if nothing changed, just make sure it still matches your real wishes. Other documents that usually get done alongside a will. Before I wrap up, let me quickly mention the other documents that usually get done alongside a will. The ones that protect you while you're alive. 1. A power of attorney lets someone you trust handle your financial life if you're unable to. Things like paying bills, accessing accounts, and managing day-to-day obligations. It prevents everything from freezing if you're sick or recovering. 2. A healthcare proxy names the person who will make medical decisions for you if you can't speak for yourself and ensures there's no confusion or fighting over who the doctors should listen to. 3. An advance directive tells doctors exactly what kinds of medical care you do or don't want in serious situations. It gives your healthcare proxy a roadmap so they're not guessing or feeling guilty. 4. And a HIPAA release allows your doctors to actually share your medical information with the people you've chosen. Even with the proxy, hospitals may stay silent without this form because privacy laws are strict. I won't go deeper here, these deserve their own videos, but just know they usually come as a package with your will. So here's the truth. A will is not about death. A will is about clarity. A will is about love. A will is about not leaving a mess behind. It's really about making life easier for the people who you love most. It's about saying, I lived a full life and I'm taking care of you even after I'm gone. You don't need to be wealthy. You don't need to be old. You don't need to have everything figured out. You just need to start. And now you know how. Whether you need a simple will or a more complete estate plan, you've got this, and we've got you. I'm Morgan, co-founder of Bridelawyer, and thank you for joining me for this entire series. You live in New York or New Jersey and are considering a will, trust, or estate plan, contact us at bridelawyer.com.